Hello everyone, I am Payal Agarwal and I present before you a regulatory review of the corporate law developments during the year 2022. 2022 has been a relatively stable year when it comes to Companies Act, save as some changes in the formats of various forms and filing procedures with increasing online processes with the launch of MCV3 portal. But significant traction has been noted on the part of SEBI. Almost all the major uh, almost all the major regulations of SEBI noticed some amendments or the other, be it the listing regulations, the ICDR regulations, or the insider trading regulations. In terms of the ICDR regulations, almost all modes of capital raising by listed entities have been impacted by the various amendments. The year started with the amendment notification on the ICDR Amendment Regulations 2022, wherein almost all aspects of preferential issuance of securities noticed some changes or the other, be it on the valuation and pricing, on the specificity of the purpose of issue, restrictions in relation to lock-in and pledge of such securities, increased disclosure requirements, eligibility conditions for issuers and investors, etc. Further, the amendments had the impact of restricting the permissibility of consideration other than cash to mean only swap of securities with the valuation thereof by a registered valuer. The requirement of monitoring of the use of proceeds raised through qualified institutional placement and preferential issuance of securities has also been notified by the circular issued by the stock exchanges. And the funds which can be used for general corporate purposes has been limited to a maximum of 25% of the funds raised through such issuances. Similar limits are also with respect to the funds raised by way of an IPO, and an amendment was noticed there wherein SEBI has brought in a stricter regulation in relation to the objects of the issue and specified that the funds raised for general corporate purposes and for unidentified acquisitions or investments cannot exceed a maximum of 35% of the total issue size. The utilization has to be monitored, including that for the general corporate purposes. Under the erstwhile ICDR regulations, monitoring agencies could be scheduled commercial banks or public financial institutions. But now the law has been amended to enable the credit rating agencies to act as monitoring agencies for the funds raised through IPO, FPO, QIP, preferential issues, and the like. Further, to ensure that the performance indicators provided in the prospectus or the offer documents are objective and measurable, the qualitative statements in the averaged prospectus is now being mandated to be substantiated with some key performance indicators and other quantitative factors. Pursuant to a very recent amendments, the issuer has been given an option to file a confidential DRHP with SEBI till the time comments are received from SEBI. After that, the DRHP, the updated DRHP, is required to be hosted on the website of the company, the lead manager, the SEBI and stock exchanges, wherein it will be open for comments for the public for at least 21 days, after which an updated DRHP will be filed with SEBI again. The issuer is required to open the IPO within 18 months from the receipt of final observations of SEBI on the updated DRHP. As we move further with the updates made to the listing regulations, SEBI introduced stricter norms for appointment or reappointment of rejected candidates, that is, the candidates which have been rejected by the shareholders earlier, and also provided an alternative mechanism for appointment and removal for independent directors. The format of the quarterly shareholding pattern filed by the listed entities has also been amended towards providing for transparency of information. While we all know that the RPT framework provided under the listing regulations was amended by the notification dated 9th November 2021, most of the changes became applicable with effect from 1st April 2022. And since there have been various ambiguity and various practical implementation difficulties, clarifications continue to be issued on the periodicity and manner of obtaining shareholders' approvals, and the stock exchanges also issued various guidance notes to that end. Initiatives have also been taken with respect to investor protection and investor convenience. Here it is important to note that while the LODR amendment regulations, now all requests of transfer, transmission can be facilitated only through dematerialized mode. Further, the procedure for issuance of duplicate share certificates has been simplified and standardized. An updated SOP for the dispute resolution mechanism was released and simplified format of the investor complaint report. While the regulations generally seem to be moving towards a stricter side, the year also witnessed that contrary to the recommendations made by the Kotak Committee, seemingly under the immense pressure from the corporate sector, including PSUs, the requirement of separation of roles of MD and chairman, which was supposed to have become mandatory with effect from 1st April 2022, has been made voluntary via press release by SEBI. The insider trading regulations continue to be evolved during the year 2022, and some amendments have been noted with respect to the framework for restricting trading by designated persons by freezing PAN at security level during trading window closure for financial results. Further, the concept of SDD, while it's found its regulatory recognition back in the year 2019, it was not before 2022 that the listed entities were woken out of sleep to understand the importance of having a proper and well-maintained SDD. It started with the stock exchanges sending separate mails to listed entities somewhere around the first week of August, thereafter releasing circulars requiring the listed entities to provide a quarterly certificate on the compliance with SDD maintenance requirements. Insider trading controls were formally and elaborately extended to the mutual funds as well. While an amendment regulation 2022, provisions have been incorporated in the existing insider trading regulations towards regulation of trading by asset management companies and trustees of mutual funds. The same has not been implemented as yet. Another landmark development in the capital markets was the introduction of the concept of social stock exchanges. The concept of social stock exchanges marked its entry in the Indian regulatory framework with the notification of amendments under the ICDR regulations, listing regulations, and the AIF regulations. Further, SEBI also issued a detailed SEC framework for the entities eligible and willing to get registered with the SEC. Both the stock exchanges having nationwide terminals, that is the BSE and NSE, have also received in-principle approval by SEBI for establishing social stock exchanges as a separate segment within the exchange. The new year is expected to witness a new dawn of responsible donations with the operationalization of SSCs in India. Also, we are hopeful that the social enterprises would want to get registered with the social stock exchanges. Some of the provisions of Companies Act have also been reviewed during the year, and the CLC released its report for public comments. The recommendations of the CLC report touch a wide array of elements under the Act, such as delinking the automatic vacation directorship to corporate defaults, extension of cooling off period, safeguards against conflict of interest of auditors, disclosure of reasons for resignation of KMPs, etc. Fast-track mergers have not really been very well taken. Possibly, with a view to simplify the approval requirement, the twin tests of special majority of voting rights for present and voting and ordinary majority of voting rights for all existing shareholders have been proposed against the existing requirement of 90% voting rights. IEPF provisions are also proposed to be extended to the unpaid monies on buybacks. Recommendations are provided to declog NCLTs by moving the restoration of struck-off companies to administrative offices. Moving further to digitalization, the recommendation permits maintenance of statutory registers in electronic form and provides the possibility of the hybrid mode corporate meetings rather than through the present practice of MCA circulars, which are valid only for the COVID restrictions. The recommendations also seek restoration of some meaningful provisions of the erstwhile Companies Act 1956, as also aligns the same with the listing regulations by providing for stringent corporate governance requirements. The provisions of CSR also continue to evolve with the notification of a web-based form CSR2 and the CSR Amendment Rules 2022, polishing the few rough ends which were left from the 2021 amendments. A very important requirement of compulsory audit trail feature with respect to maintenance of books of accounts in electronic form got deferred and will be applicable with effect from 1st April 2023. Further, the manner of maintaining books of accounts in electronic form has been further amended to require companies to maintain backup of electronic records in physical servers located in India on a daily basis instead of the erstwhile provision of a periodic basis. And details of the service provider, if located outside India, is required to be intimated to ROC on an annual basis along with filing of the financial statements. The procedure for physical verification of registered offices by ROC has been notified in furtherance of the powers provided under Section 12(9) of the Companies Act. The ambit of small companies has been broadened with the increase in thresholds of paid-up capital and net worth for small companies. The NDI Amendment Rules mandates prior approval for foreign investment from countries sharing land borders with India. Hence, relevant rules have been amended to require a proposed director, if a national of a country sharing land borders with India, to obtain security clearance from the government and attach the same in appointment-related filings such as DIR-2 and DIR-3. Similar amendments have been noted in the incorporation rules, the compromise and arrangement rules, etc. A notable change during the year has been the extension of certain provisions of Companies Act to LLPs as well. The LLP structure is preferred by various organizations over the recent years as a structure for regulatory arbitrage. Some of these regulatory gaps are being gradually plugged up with the provisions of Companies Act, such as declaration of significant beneficial owners, provisions pertaining to disqualification and vacation of office of directors extended to designated persons, power of inspection and provisions pertaining to restoration of name of struck of LLPs being incorporated to the in the LLP Act as well. Further, the amended LLP rules during the year provided way for decriminalization of various offences under the LLP Act. Certain amendments have been noted by the debt-listed entities and the long-term capital bond markets in general. The most important of these is the regulation of online bond platforms. To this effect, the NCS regulations have been amended to bar the intermediaries from facilitating transactions in listed debt securities without a stockbroker license, and the regulatory framework for online bond platform providers have been notified. Certain amendments have been notified to the EBP mechanism, and a further cap has been introduced to the maximum number of ISINs that can mature in a year. A distributed ledger technology has been introduced towards recording and monitoring of security created on the secured non-convertible securities and monitoring of covenants thereof. Enhanced guidelines have also been issued with respect to monitoring and due diligence by debenture trustees. Now, as the year ends, the listed entities need to prepare themselves for the year 2023. Some of the various actionables on the part of the listed entities during the year 2023 would be, first of all, various entities which are identified as the large corporate borrowers will witness the end of the first 2 years block of mandatory compliance with the framework with the period ending March 2023. And the failure to comply with the requirements will attract monetary penalties. The corporate governance provisions under the listing regulations that are currently extended to the high value debt listed entities as well on a comply or explain basis will become mandatorily applicable with effect from 1st April 2023. Certain provisions of the amended RPT framework under the listing regulations will also become applicable to the listed entities with effect from 1st April 2023. These majorly includes the purpose and effect test for identification of RPTs and reducing the threshold of shareholding from 20% to 10% for being reckoned as a related party. A lot more transactions done by the subsidiaries of listed entities will now fall within the caption of material transactions, with the definition of material transactions undergoing a change. Financial year 22-23 will be the first year for mandatory reporting of business responsibility and sustainability report by the top 1,000 listed entities. Further, as already mentioned, we expect the social stock exchanges to be operationalized, and we expect significant interest from the social enterprises to list therein, even if not for the purpose of raising responsible contributions, but more for aligning themselves with the discipline and disclosure requirements of an SEC listed entity. Further, SEBI, in its recent board meeting held on 20th December 2022, has approved various amendments to the buyback regulations, to the NCS regulations towards raising sustainable finance, amendments pertaining to the REITs, InvITs, mutual funds, etc. A major theme for the listed entities may be the mandatory disclosures for material events and information. To this effect, a consultation paper has already been issued on the review of disclosure requirements, and therefore Regulation 30 of the LODR, read with Schedule 3 thereto, is expected to undergo significant amendments shortly. We expect another important regulatory theme to be climate change. On the ESG front, regulations are expected on the ESG rating providers. With the parliamentary approval on the Energy Conservation Amendment Bill, the carbon trading markets may also commence operations shortly in India on a national level. Since the RBI has also released a discussion paper on TCFDs, we expect that financial entities may soon be required to make disclosures on climate risk. We hope this may contribute a penny to the lofty cause of mitigating climate change. This video was to give you a brief of the various amendments that the year 2022 has witnessed. We have detailed resources on each of the subjects which is available on our website. The link of the reference material used for this video is given in the description box. Thank you for watching and a Happy New Year to all of you.